Padre Walsh, come on up. Padre Walsh, partner at Tanner DeWitt, leading technology and legal firm in Hong Kong. Thanks for joining us, Padre. We are also welcoming Ronald Yu. Ronald Yu is a visiting fellow to the WOW Summit today, but he's also the director of the Arctic Aurora Advisory Services and going to be joining us today. And we're bringing back to the stage after she's had a chance to rest after her tour de force, Tan Bin Rue, the Deputy CEO and Chief Operating Officer with Chainhub. So Tan Bin Rue, welcome back to the stage. Padre, I leave you in command of this platform. Take it away.
Thank you all. So we had a wonderful introduction to Chainhub from Bin Rue in the last session, but what I might ask Ron is if you can just introduce yourself with a hashtag in the shortest way possible, and then we'll get into the content of the session.
Hi, I'm Ron. My background is actually from engineering originally, but then I went into law when I was a bit older, and I've actually stumbled into IP and stayed there for some time. And I'm actually currently teaching a class in patent law at City University, and before that I was co-teaching a class at FinTech at Chinese U.
Sounds like you're right on point in respect of the topic for today. We're going to speak about blockchain technology and intellectual property rights, but we're going to do so in order to move to what that means, particularly in a Web3 environment, because that's something that's exercising the minds of a lot of very smart people, both in respect of the legal profession, the IP profession, and in business. And across the panel today, we have good insights coming from industry as well as from the legal profession itself. Ron, if I could start with you, maybe with the first question, just to introduce what is the traditional value that's ascribed to intellectual property protection? In the traditional world, the pre-Web3 world, what is it about IP that people think this is important, this is why we register it, this is why we protect it, this is why we enforce it?
The original premise of intellectual property was to promote creation and promote invention. So if you look at intellectual property laws, and from a policy standpoint, they're designed to basically encourage invention or creation by giving people certain rights for their creations, certain privileges as in terms of control of the rights, as well as a way to achieve certain recognition for what they have contributed. As a result, this is the basis for commercialization, and this is why people find intellectual property so valuable, because of these rights are providing them with the ability to earn money. Now, also from a government or other policy standpoint, you see that people have been using intellectual property rights to promote innovation for their own economies. For example, if you look at the very first patent laws from Venice from 1474, they created the patent laws to attract glassmakers to Venice so that Venice would have a competitive edge over rivals. So this is why intellectual property to a lot of people is so very important.
And if we're to take that on, one of the things I really liked, Bin Rue, in your presentation earlier was how you mentioned that as you've progressed in your career, the average age of those people you're working with has reduced. I would use the analogy of the, how my hairline is receding, but I take the point. In that, one of the things that I took from it is that you have come from, certainly within a technology and a fintech environment, but you've come from a traditional Web 2 environment. And can you explain what the attitude was that you came across in those roles to intellectual property protection and enforcement? So in the Web 2 world, what's the traditional view from a business perspective to the relevance and importance of IP?
So I joined, if I may kind of backtrack a little, when I joined Microsoft, it was all about proprietary tech, right? So it was all about proprietary tech. Of course, Microsoft under Satya then has moved to embrace open source for a while, but it was for the longest time proprietary tech. We do our sales in Microsoft by servicing you a compliance letter So if you receive your compliance letter, you will naturally then switch to a genuine solution. So it's everything about IP. When I joined One Connect in Ping An, Ping An is one of the largest contributor to IP patents in AI, together with Alibaba, and the two of them were competing in terms of the number of patents that's filed on AI. So when I started One Connect International, I started filing all the patents in Singapore, so it was a lot of money, but but that was how Web 2 is, it's so important to protect your IP.
And building on that and staying with you, Binru, so if you think of what a patent protection is, it's essentially a trade-off between a monopoly, exclusive monopoly right to exploit a right commercially, as against the obligation to publish what that innovation or that invention is. So that's a traditional view. Now, if we come into the Web3 environment, one of the things that was very interesting in our preparation for this session is that you mentioned that at ChainUp, it's a different approach. Now, so elaborate on that and explain how much IP has been registered in the development of the technologies that ChainUp have produced, and explain what's the thinking behind that kind of approach and that kind of strategy.
Yes, so at ChainUp for 5 years, we've gotten so much experience in building the crypto tech, but we patented nothing. We patented nothing. And the first thing I asked the founder, why didn't we patent anything? What is your competitive edge then? To a lot of our customers, in order to go live, meeting their regulatory requirements, we also gave them the source code. And the thinking behind the founder, I think, is very unique, and it tells you a lot about the industry, because it's such a nascent industry. A lot of things are still changing and moving so fast. Whatever that is valuable today, in the traditional world, IP will be valuable for, say, 6-7 years, or minimally. Yeah, in the Web3 space, things just kind of evolve and it's outdated in a year or 18 months, right? So basically, we went after what the customer needs. Yeah, and it was, these 5 years, just the last thing we think about is proprietary anything or patenting anything, right or wrong. That's the thought process.
Which strikes shock and horror to the heart of a lawyer who, earns a living, earns a crust by virtue of IP protection and enforcement. But it's a view and a perspective that I've heard from others within the industry. And if I could turn to Ron and just to explore this theme a little bit more, because if you think of what's at the heart or at the root of the Web3 ethos is a decentralized, community-based form of connecting between groups of people. So in that kind of environment, what relevance does intellectual property have, particularly in the context of enforcement? Who do you enforce against? Where do you enforce? How do you, does the fact of the characteristics of Web3 mean that intellectual property has less or no value?
Well, I think the notion of a shared communal environment with communal cooperation and collaboration is a very good ideal to achieve. Fortunately or unfortunately for the IP lawyers, there's always human nature to fall back upon. And unfortunately, I think human nature being what it is that disputes do arise, and that people will want some kind of mechanism and some kind of certainty, legal certainty as to where they go to solve their problems. Now, this is especially true if they start to feel that they are not, their intellectual property and intellectual contributions are not respected, or they're not getting adequate recognition or remuneration. Now, in history, we actually have something similar to the current Web3 environment in the open source environment. Because if you look at the history of the open source environment, it started as a collaborative environment. And it was a very open community. People would share freely, but they had certain rules in terms of how they shared, and they wanted recognition. But then, of course, if these rules were broken, there was quite a bit of, shall we say, negative feedback. In fact, there's actually a case in the United States, a class action against GitHub for their Copilot system and OpenAI for Codex. And at the heart of it is the fact that Codex and Copilot and some of the other AI-powered code generators are creating a lot of code that is allegedly being used by open sources, but without the recognition of the original author. So in that sense, there is still a need for some form of intellectual property protection, or at least intellectual property recognition.
The questions for this session have been created by Padraig Walsh. That's with a C and a circle around it. So there's my recognition. With that, I mean, again, coming back to you, Binru, in respect of issues within business, one of the traditional things that IP is intended to protect is that if you're developing, creating something, and there's R&D and there's creativity, there's cost, there's expense that's involved in that, the monopoly or the exclusivity that you get in respect of protecting that right in itself causes a barrier to entry. So essentially, someone can't come steal the work that you've done, steal in inverted commas, and then get a jump on the market in respect of competing with you. So if ChainUp, I use ChainUp just as an illustrative example, if ChainUp hasn't focused upon IP for that purpose, does that mean that someone can steal ChainUp's lunch much easier? Are you easier to compete against?
Before I answer that on ChainUp, I will ask the audience whether you know about algorithm decays, in AI. When I first started selling AI solutions, we were very concerned about someone stealing it. But it's really not easy to steal an AI solution because why? The underlying data builds that algorithm, and the algorithm is a mathematical formula. So you can steal the mathematical formula, you don't have the underlying that built it up to improve upon it. So in 6 months' time, it decays. It decays. So if you have been using facial recognition, and then when on COVID, you didn't upgrade the algorithm. After COVID, you are a little fatter, and your hair is a little longer. The algorithm cannot recognize you anymore. So what is valuable today, 6 months later, is not valuable anymore. And to ChainUp, I kind of understand the founders' thinking because the team is so busy with learning the next new tech, improving the next module, meeting the customers' requirements, meeting demand in the market, that's not a thing of priority currently. But I wouldn't rule out that in the near future it might be a priority. So if you want to buy our source code, you buy it now because it won't be there.
So in that sense, I think there's pace to market and the pace of the market. So in terms of development, it's always, and it's true even in the traditional world, that there is a trade-off between how fast you develop something and the protection of IP rights can be a drag or a friction in respect of how fast you're able to get to market. That part I certainly understand. The other thing that occurred to me just in respect of that is certainly, there are other barriers to entry or to competition generally. And within our world, we would think of, for instance, the impact of regulation, that license holders and the ability to get a license, that in itself creates a barrier to entry. The level of specialized technical knowledge that is needed in respect of, say, a business such as ChainUp, both in terms of the technology, both in terms of the people that you need to hire in order to be able to execute the business. These are all very, very high hurdles for people to overcome. Well, what's interesting is that in the traditional world, IP would be right up there, and that's now part of the conversation in respect of Web3. But maybe to give some examples in respect of where we see, some cases coming through. I mean, if you look at cases, I look at them as just stories of things that have gone right or wrong, according to whether you win or lose in the action in question, but they're illustrative of the kinds of disputes that are coming through because of the new legal issues that are involved. And Ron, you wanted to highlight Zarya of the Dawn, and so please tell us what happened in that case and how we know that a robot cannot necessarily own patents.
Well, this actually goes to a very complicated question. You've sort of hinted as to how you actually enforce something, and unfortunately it goes to the reality of where you enforce. In the case of Zarya, what you had was Chris, and gosh, I got a lot. What's her last name now? Anyway, the author had created a comic book, and she wrote the script and the content, but she used a Mid-Journey to create the imaging. Now, the problem that she had was the Copyright Office in America had originally allowed her to get copyright for her entire work, but then came back and said because the images were created by Mid-Journey, there was no copyright protection. Now, in Hong Kong, this might have gone the other differently, but the point of the matter is that a lot of the regulators are now struggling with the notion of intellectual property created by an artificial intelligence. And so I think this question will become more apparent. And it also highlights the problem that if you actually have any IP disputes in the metaverse or the Web3 world, where you go to resolve your dispute makes a big difference.
One of the this Zarya of the Dawn was specifically a copyright case, and in the US you can go for copyright registration, which is not necessarily the case elsewhere. But one of the things that's interesting there is that you think of AI as being a tool, as much as being it's a creative element, but not necessarily the creator. And that's the issue that the authorities are struggling with and the case law is struggling with. And what you can see is that there are different outcomes in different places. And this is important within the Web3 environment, because looking at one of the slides that Binru shared, where you looked at the activities within the industry as a whole, that media and entertainment slice, it's relatively small. I was surprised at how narrow it was, but that's going to expand quite a lot, because the real promise, one of the real promises in respect of Web3 is in that whole area of media and entertainment. And within that, copyright protection, trademark protection with the Meta Birkins case are really core and critical. Now, I'm not sure, I think time might allow us to have one more question, and I did want to speak about, Binru referred earlier to, not having the time in her packed schedule for shopping, but I was wondering whether Binru might be interested in the Birkins handbags that Hermes produce. But Ron knows something about the Meta Birkins case, which is a trademark-based case. And one of the things that I'd like you to draw out, Ron, if you could, is that different approaches within the Web3 community are being taken according to the kind of IP right that's involved. So we've spoken about copyright.
This is a copyright, a trademark dispute, but there's also, for those lawyers in the audience, there's also passing off. But essentially what had happened, if you're not familiar with the case, was in 2021, Mason Rothschild had created some Meta Birkins, basically fuzzy blue fur versions of Birkins, and he sold them as NFTs. Now, part of the problem was that people had thought that these were sponsored or there was some involvement by Hermes, but in fact there wasn't. So there was a lawsuit brought against Rothschild by Hermes in the United States, actually specifically in the Southern District Court of New York. Now, this is actually important. It goes back even further into the notion of jurisdiction that I kind of hinted at, because the America interestingly enough, doesn't actually apply a uniform standard for trademark infringement, just to let you know. But in the case of Rothschild, he did they applied what is called a Rogers test. This is for the IP people, who want to ace their exams. But anyway, to make a long story short, this test allows people to claim certain kinds of rights as in terms of expression, and so there's a bit of an out for these people. Now, other parts of the United States and in Hong Kong, the test is whether you actually have caused confusion. Now, the point I'm making here is that the tests for intellectual property are not only different from country to country. In the case of the United States, they may be different from state to state, which makes things a little bit messier and a little bit more confusing for people.
So that's a trademark case, and what you find within Web3, particularly if it's something that's in media entertainment or in retail, is that trademark protection is still very important in that environment. You see a different approach being taken in respect of maybe patent protection, as Binru has explained.
I totally respect the trademark and copyright for Birkins. So from a handbag perspective, please respect the IP rights of the trademark. That's very important to a woman.
Yes. and also copyright has a different view in respect of Web3. But I think that actually brings us kind of nicely to the close of our panel. So it just leaves me to thank Binru and Ron. Thank you so much for your kind contributions and for your sharing with the audience. Thank you for your attention.
Thank you, everybody.